Heggstad Petition, transferring property to a trust. That's our topic today. Let's get started right after this. Hi, I'm Kim Ward, certified probate real estate advisor, developer of ProbateBiz.com, and online training for real estate agents to learn how to help with properties that are in probate like I do. Are you wondering about the Heggstad Petition, transferring property to a trust? Let's get started. But before we do that, if you're truly interested in a business model like mine, helping executors and administrators with homes in probate, you're going to want to join us for my next webinar. We'll talk about the 6 questions that real estate agents have about starting a probate real estate business, and I will answer as many of your specific questions as I can. I'll be letting you know in my future videos when we have the webinar planned, but you can also go to my Facebook page, ProbateBiz, where we will post the dates and times. So the Heggstad Petition is pretty much about fixing the decedent's mistakes after they pass away. It's primarily used when the decedent, for whatever reason, did not put a piece of real property into their trust. It's typically pretty helpful when it's pretty obvious that the decedent meant to have the real property in the trust, but for whatever reason didn't. And that's what we'll be sharing more about, how it happens and how to get it back into the trust. Much of the time when an owner goes about refinancing their property, the deed needs to be removed from the trust and put into the individual's name. And a lot of the time, for whatever reason, it does not get put back into the trust. Frankly, I think that the lenders and the escrow companies that are involved with doing the refinance should definitely help the owner get the property back into the trust, but it frequently does not happen. And much of the time, the owner has no idea of what they've actually done, removing their property from the trust, and they don't know who to ask to help to get it back into the trust. Now, you and I know it's as simple as doing a new deed and getting it recorded, but your typical owner does not have any idea about that. And then what happens is they pass away, and all of a sudden it's realized that the property is not in the trust where it belonged. Then the personal representative, or in a lot of cases the trustee, will find out about it, and they'll be wondering, now what do I do? That's where you can come in, if the attorney hasn't already helped your client, by letting them know about the Heggstad Petition. What it will do, it will allow the courts to put the property, the home of the decedent, back into the trust and keep your client, the trustee, from not having to go through a lengthy process of probate. A successful Heggstad petition results in a judgment confirming that the property, although it was not legally put into the trust, that the intention was for that property to be held within the trust. Probate Code Section 850 governs Heggstad petitions. The name comes from the 1993 California Probate Code of the estate of Heggstad. In that particular case, the decedent owned a portion of a piece of real property. The decedent had made a schedule of assets identifying which assets he wanted in the trust, and that included his interest in the real property. Unfortunately, he failed to correctly transfer that property into the trust. After he passed away, his family went to court and claimed that Heggstad had intended to include that property in his trust. In that particular case, the California Probate Court used the schedule of assets to show that, yes, his intention was to have had that real property held in the trust. The probate court then titled that property as part of the trust without any further court proceedings. I'll continue on with the Heggstad Petition. I hope you by now realize that I really try to have topics of interest to you if you're interested in probate real estate. If you're finding this of value, hit that like button, and don't forget to subscribe and hit the bell button to be informed of my weekly videos, because you wouldn't want to miss any of them. So let's continue. Again, the most common situation involving a Heggstad petition is because, for whatever reason, the property was not properly put into the trust. Some of those assets could include bank accounts as well as real property. Unfortunately, some trust creators forget this so important step. like I said earlier, and forget to move the property back into the trust using the proper deed. A Heggstad petition is usually necessary because of the following situations. The decedent forgot or didn't know they were supposed to transfer the property into the trust, and why would they know? They were ill and couldn't complete the transfer, or paperwork was flawed and failed to complete the proper transfer. The most important part that helps to get the Heggstad petition in place is that the decedent, they intended to have whatever that asset was, the bank account, the real property, whatever it might be, they intended to hold it in the trust. Now, as far as timeline, it could take 2 to 4 months to get completely through the process, but it's a real big benefit for your client because it avoids that lengthy and expensive process of going through probate. So I hope you found this of value. Again, please subscribe to my channel. Please put your comments below. And if you have questions, post those below also. Keep an eye out for my webinar where we'll be talking all about having a successful real estate business, helping executors and administrators through the process of probate. See you next week.